how information technology is being used all across, and then accordingly, I think we can go ahead with the other portions. So now, to start off, first we will cover first. I think on the last occasion we had covered portions of the World Intellectual Property Organization and its link with the Internet Corporation for Assigned Names and Numbers. So ICANN. We were discussing the Uniform Domain Name Dispute Resolution Policy, and we'll get some more idea on the Uniform Domain Name Dispute Resolution Policy. I thought it's best that all of us go through the policy. It will give us some idea regarding the policy, and also we'll go through the rules in brief. We'll get some idea on the rules of what it is and how to go about it, and then accordingly we will be, I think, in a position to move ahead with the information technology. So it will give us the objective of information technology within this is to get an idea of what the Information Technology Act entails. We'll cover substantial portions of it. I think we'll stop by at the most relevant portions, and then accordingly, I think the remaining portions of the Information Technology Act we can go through at our own convenience later on, and then we'll be in a position. So now, first is in the last on the last occasion we had had some brief on what Uniform Domain Name Dispute Resolution Policy is, and why online dispute resolution is taking effect in India, and how one should go about it. So now let's start with this. Let me put this question to the House. So what, according to us, would imply and mean Uniform Domain Name Dispute Resolution Policy? What do we think UDRP stands for and means? So I think let the questions let your answers come in. So accordingly, we'll be able to proceed. If the name is appearing incorrectly, you tell me. Mr. Avinash Shukla has written to register unique ID on the web. Yes, this has got something to do with it. But when we talk of UDRP, we mean Uniform Domain Name Dispute Resolution Policy. So it essentially talks of a dispute resolution policy. So what do we mean by that dispute resolution policy? So yes, Mr. Shukla, you are on track. So I think we can go a bit further and then get an understanding of what UDRP would mean. Identify the user again. If the name is not appearing correctly, please tell me. Mr. Sushant Gupta has written identify the user. You are on track, not exactly identifying the user. That's not the objective of it. We are essentially looking at a dispute resolution mechanism. So what, without further ado, I think we can dispute over infringement of an ID already registered. Again, tell me if the Mr. Shukla, good attempt. It's a good attempt. So yeah. So let's see what does this have to do. What does this mean essentially? So let's see, and then I think we'll see the policy. Mr. Shukla, you are close. You are quite close. Let's see. Let's start off with what UDRP means. Yeah. You see, as you can see on the screen, I'll put it. Yeah, I think this would be better. As you can see on the screen, it is known as the Uniform Domain Name Dispute Resolution Policy. Now, this was adopted in 1999. This is administered by the World Intellectual Property Organization. Policy is in effect Now, a policy has been adopted by all accredited domain name registrars for domain names ending in .com, .net, and .org. It has also been adopted by certain managers of country code, top level domains. So every country would be having its own code. So, say for example, with India, it is .in. So the country code registrars have also adopted it. Again, so who between whom does this policy take effect? Between the registrar or the registration authority with respect to any country and the customer. Who is the customer? Customer in this case is not the end user. The customer is the domain name holder or registrant. Say, with respect to say ICMAI. So again, when a website is being registered, so in that case, the cost accountants would also be having a website, and say icmi.in. So here the relationship is between the registration authority and say ICMI. ICMI is the customer. Since it's a .in domain, that domain is not used. Would not come within the ambit of this UDRP. So let's see what is the purpose of this. If you can see on the screen, so essentially it is the registration and use of an internet domain. We will be going through the rules of procedure. Now, essentially, if you look at it, UDRP policy, it sets out the legal framework for the resolution of disputes between essentially a domain name registrant and a third party, that is a party other than the registrar, over the any registration which we may deem to be abusive, uh, say and where an internet domain name is there in the generic domains, say, which would also include right, as we can see, as we've seen, .com, .net, .org. It would also include say .mobi, .info, .base, all of these, which are the generic top level domains, which are called GTLDs in short, and some country code top level domains which have adopted UDRP. It is entirely voluntary for country codes to accept this. Now, this was essentially accepted in there were meetings in Santiago, Chile in '99, and then the ICANN board of directors, they adopted the UDRP policy. Now, this UDRP policy, if you look at it, was based on the recommendations given by a WIPO body, which is the you know there was a report which was known as the WIPO Internet Domain Name Process Report. So based on those recommendations, and where comments were given by the registrars and the interested parties, so they're all ICANN registered registrars have adopted the policy, and they've said that we will be abiding by those and implementing it in their domains. So now, in case they will want to use it, they will have to give consent to it. Now, the rules were adopted, which were known as the UDRP rules. Then we know from October 24, as we can see on the screen, 99. Now, the rules will give the procedures and the requirements for every step of the dispute resolution process, including the administrative procedure. And the procedure is generally administered by the dispute resolution service providers, which are accredited by the ICANN. And for example, just to give an example of a service provider, it would be, say, for example, the WIPO Arbitration and Mediation Center, which again administers and provides administrative support. Now, technical advisory to ICANN was given by WIPO, as again it's more or less a WIPO undertaking. Now, apart from the UDRP policy and rules, we also have the supplementary rules. That is something which we'll not do in great detail. Now, primarily, if you look at it, so now this purpose is over. As you go down, we are talking of representations. So there, as you can see, by moment one asks for application or renewal of a domain name. Domain name is basically the name of the website, as we can see on the screen. So there is an implicit undertaking that one will have to, there are these 4 essential undertakings, that the information is complete and the registration will not infringe upon or violate the rights of any third party, which would essentially mean that it will not violate the rights of any other website in that sense. And then it's not for an unlawful purpose, and essentially not use the domain name in violation of applicable laws or regulations. So I mean, this is there. And the background check has to be done at the end of the registrant, person who's applying for the registration, and based on the background check, then they will be asked to and the undertakings, the registration will be done. Now, domain, this is the domain name registration. Now let's go down and see the cancellations, transfer changes. Domain name registration changes, how this is possible. One is by self, the other is by a direction of a court, which is B. Now, then the third is the administrative panel decision. So again, there are circumstances and situations where the name can be cancelled and changed. Mandatory administrative. Now this is where we come in. The mandatory administrative proceeding. This the types of disputes which have to be submitted for a mandatory administrative proceeding, as we've seen, based on the directions of a mandatory administrative proceeding, changes, cancellations, amendments can be made. Now the proceedings will be conducted before the administrative dispute resolution service providers. For example, WIPO Arbitration and Mediation Center is one. Now, this administrative proceeding is mandatory, and we will come to what are the types of disputes which can be referred to, for administrative dispute resolution. Now, first is who can apply for this administrative process. We are talking of an administrative procedure through an administrative institution. Now, the first is who can approach, and we are looking at a dispute resolution. Essentially, most of the disputes arise when you have essentially a violation of a domain name. So now the administrative procedure can be initiated by anyone, essentially any corporate entity, any legal entity. It can be a person, it can be a company. Anyone can file a domain name complaint, which can be regarding a generic top level domain using the UDRP administrative procedure. So essentially, with respect to the generic top level domains, which could be your .com, .org, .info, .biz, .mobi, and the others who have voluntarily submitted to UDRP dispute resolution mechanism. So then they can have apply for, or at least register a complaint for using the administrative procedure under the UDRP. Now, we've spoken of the voluntary ones, and the countries which have voluntarily accepted uniform dispute domain name dispute resolution process by way of this organization, that list can be available. It's available there on the website of WIPO and stuff. So now we come to the portion under this is paragraph 4a, which deals with applicable disputes. Essentially, what kind of disputes can be referred for this kind of dispute resolution. So the administrative proceeding is mandatory in case the complainant says that because if you look at it, there are thousands of websites which have come up, and there are websites which really say, for example, today someone comes up with a website which is very close to ICMAI, for example. So it's like, say, ICMAI, dot in. So in that case, again, ICMI will be entitled to approach and say that, see, this name is deceptively similar to our name. And then, of course, someone uses the name ICMI in some other wrong fashion in a domain name. In that case, again, that registered domain name can be challenged by any person or even a company or even any other corporated or incorporated entity. So what is there? So it's a mandatory administrative proceeding. With respect to, say, Indian domain names, we have a .in domain name dispute resolution procedure. So that's separate from UDRP, although largely based on UDRP. Now, what does one have to show in order to make a complaint? One has to show that the domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. So essentially, the name should be the domain name, which is in normal parlance we call it the abusive registration. Now it has to follow the uh, satisfy the conditions and the criteria. So now the first is your domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. And so essentially it means it is not exhaustive. It has also to come under the other portions of the domain name which is there. So all these conditions have to be satisfied. Now first condition is the domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. So the domain name has to be similar. Now the second is it has to be similar to what uh, trademark or service mark in which the complainant has rights, and you have no rights or legitimate interests in respect of in which the complainant has rights. So essentially it should be shown that the complainant has rights, but the party who's registered does not have rights to register. So this is there. It should be violating a trademark or a service mark. Now trademark registration and all, this is something which will not get into depths of intellectual property, but basically it should be similar sound. We suffice it to say that this should be similar sounding names. Now they have the domain name has been registered and is being used in bad faith. So there has to be not merely it has to be under application. The domain name has to be registered. The domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights, and then the person who's registered has no rights. Moving on. So in the administrative proceeding, the complainant must prove that each of these three elements are present. Now let's move on to paragraph 4b. This is very important. I have A and B. These are quite important. Now in 4a, this B talks of evidence of registration and use in bad faith. Now if you look at A clause 1 talks of domain name is identical or confusingly similar to a trademark or service clause 3 talks of domain name has been registered and is being used in bad faith. So now here 4b defines what is 4a3, which is essentially this portion is what 4b defines. 4b, what does it say? For the purposes of 4a3, the following circumstances in particular, but without limitation, if found by the panel to be present, shall be evidence of the registration and use of a domain name in bad faith. As you can see on the screen, so first is to, if say someone, now there is say a new corporate entity which is doing well. Say for example, in rural India, there is a corporate entity which is doing really well. Now, which is say for example, selling handicrafts. Now they don't have a website. They, although they are making good sale of say physical goods. However, website is absent. Now there are maybe 10 entities of this kind. Now one rogue gentleman goes and registers names of these handicraft selling entities and units, and then now says, see, I've registered it in your using your name, you'll have to pay me so much, so I'll transfer that name to you. This is something which is deemed to have been used in bad faith. And say, or that gentleman says that, see, I've registered it and now I'll be selling it to some other portion, some other entity who's also challenging the or who's a competitor in market of the initial entity. So this is again, this is told to be in bad faith, or so it means it's disjunctive. So either of these conditions being satisfied will suffice. You have the domain name is registered in order to prevent the owner from reflecting the mark in a corresponding domain name, provided you've engaged in a pattern of such conduct. So therefore, it has to be seen that this would essentially prevent the owner of the mark, could be a trademark or a service mark, from registering in another domain name which they can create. So then it will, with, to essentially prevent or to mislead the owner. Now 3 talks of disrupting the business, basically acting as a competition. Now 4 talks of attracting users to the website for making commercial gain, and then or creating a confusion, maybe encashing the goodwill which is built by the original entity. You can read, it's there on the screen. Moving on, how to demonstrate your rights to and legitimate interests in the domain name. Now when a complaint is received, paragraph 5, we will go through it right now, of the rules of procedure in determining how your response should be prepared. Any of the following circumstances shall demonstrate the rights to the domain name. So in case a complaint is made against an entity, how does that entity satisfy? Uh, First is before any notice, then the use, preparation to use the domain name or the or a corresponding domain name with the bona fide offering of goods or services. So the intention has to be important, and then the conduct is to be seen, or rather demonstrated before the panel. Now the person complained against is known by the domain name. as you can see, non-commercial fair use. So first to deal with one is to, these are the defenses, that the conduct can be demonstrated and it can be shown that this is with a bona fide offering of whatever goods they are trying to sell. And in case, even if the trademark or service mark is not registered, if it's registered, it takes effect in all the corresponding countries which have acceded to the convention. This is but even if there is no registered trademark or service mark, but the company is known by that name, and then they are making a legitimate fair use of the domain name. Moving on, selection of provider. Uh, the provider, it can be your WIPO arbitration and mediation center, it can be any other center which is recognized. Initiation of proceeding and process and appointment of administrative panel. Rules of procedure will decide. What is consolidation? You saw an exception being given in B, where it says that this will apply, the selected procedure provider will administer except consolidation. What does consolidation mean? Consolidation would be multiple disputes between you and a complainant. Either you or the complainant may petition to consolidate the disputes before a single administrative panel. The petition shall be made to the first administrative panel appointed to hear, may consolidate. So now again, several disputes between the same parties may be consolidated. Now this is something interesting which we will see when we are doing arbitration, that what if there are several disputes between two parties and whether these arbitrations can be consolidated or not. Moving on, fees is okay, very well. It's as per the rules of procedure, we can leave that out. What is the involvement of WIPO, ICANN? We will not participate. The remedies shall be limited to acquiring the consultation. What is the remedy? What is the relief that one can pray? One can pray for cancellation of the domain name or the transfer of the domain name in the name of the complainant. These are the two kinds of remedies that one can ask for. Mind you, we are not looking at the entire contents of a website. We are primarily looking at the domain name, which is essentially the name of the website, or the link to a website. Notification and publication. Decisions will be published. Essentially talks of it would also show to the world as to who are the legitimate owners of a domain name. So that is why publication assumes significance. What happens in case it clashes with court proceedings? Now, it will not prevent any party to approach a court for either before or after mandatory administrative proceeding. However, mind you, the policy does not talk of doing away with the administrative panel or mandatory administrative proceeding. Now, basically, in case they will want to go and approach a court, they will wait for some time. It also does not infringe on the jurisdiction of the local courts. Now, that local courts could be the principal office of WIPO or the location of or the address of the complainant. Now, with respect to the other disputes, it does not talk of, it is kept limited only to the domain name dispute resolution policy. What is the involvement? Uh, they will not participate in the dispute. They should not be made even a party. And while this is pending, no changes in the domain name would be made. Moving on. I mean, you can see it up on the screen. Moving on. Transfers of a domain name to a new holder. During the dispute resolution process, before in the pending administrative proceeding, the domain name cannot be transferred to another party, and even after the period of 15 days. Earlier we had seen the period of implementation is 10 days unless any party approaches the court or initiates any other proceeding, and here it is 15 days. During a pending court proceeding, arbitration proceeding, it may not be transferred. So essentially, while the dispute is being adjudicated, transfer should not happen. Now they may cancel the transfer of the domain name. Changing registrars, say for example from country A to country B. Now again, what happens in the case of a transfer? The policy again can be modified and all with ICANN. Then we'll have to keep track. Now, now that we've glanced through it, I would not want to spend so much of time going through the exact details and would not want to essentially go do a line by line approach, although that would have been the best one. But nevertheless, you could see and read on this from the screen. Now, after reading all of this question may arise in our minds that what is it that why should one go for this UDRP administrative procedure? It is mandatory, no doubt, but at the same point of time, there would be some advantages attached to it. So after going through this policy, maybe we can think of those um, advantages. After this, I'll also cover the rules, and once the rules are covered, then I think we can discuss the advantages on or not of now. Mr. Gupta, any financial losses compensated for domain name? Interestingly, the policy does not talk of it. Uh, the policy does not talk of the financial losses, but nevertheless, that's interesting. That's again a very important concept, because in case someone's made a lot of money and by misleading people and directing users of some goods or services to make financial benefits, in that case they should be compensated. But perhaps, as we've seen in the policy, we've not seen that. That's a very interesting and important question that you've raised. We'll be discussing the merits and demerits of all of these. Now, what is the bench for hearing these disputes? Again, Mr. Vijay Gupta. Now, the bench for hearing these disputes is essentially wherever you will, to whichever service provider you want to go to, and then you can approach these service providers. And so it may vary from service provider to provider, and it could be your, say, WIPO office, it could be some other service provider. There's a whole list of service providers given, and it's if you ask me about WIPO is headquartered in Geneva, Switzerland, and its parent organization is the United Nations Economic and Social Council. So WIPO is being framed under that. uh, Now this is there, and with respect to, let's go through the um, policy and all, the rules rather. Now, as far as your ICANN is concerned, it is headquartered in Los Angeles, California, United States, and should be, yeah. And let's go through the rules, then I think we'll be getting some idea. Then, as Mr. Gupta raised a very important point as to what are the we'll be discussing the merits and demerits of this policy. So first, let us go through the rules once. Let's quickly go over the rules. The administrative proceedings would be governed by the rules and supplemental rules of the provider. Provider is the agency which or the authority before which the disputes will be referred to, and complainant we've seen. Who can complain? We've seen any individual or corporate entity. To put it in very, very simple words, these, for those of us who are trying to figure out what does this refer to, this essentially refers to disputes between two entities pertaining to a domain name. Domain name is essentially could be a website. ICANN, we know. What is a lock? Lock would be the measures that the registrar applies. Registered is where it is registered, the domain name, which prevents modification. Now, mutual jurisdiction, where principal office of the registrar, which is provided the domain name holder has submitted disputes to adjudication, or domain name holder's address. So that's the mutual jurisdiction. Panel would be an administrative panel appointed by a provider. So this is what we were discussing. What does a panel mean? It is an administrative panel essentially. Now, next we can, what is a panelist? Party is a complainant respondent. Pendency would be, as you can see, policy is the policy which we've just covered. I'm not going line by line, it's up there on the screen, so we can quickly read through it. Moving on, provider. This is something, someone asked a question as to where is the location of this provider. This is the provider, which refers to dispute resolution service providers approved by ICANN. Registrar, again, the entity with which the name is, the domain name or the website name is registered. Registration agreement between the registrar and the domain name holder. Now here, who is a respondent? Respondent is someone who's responding. We have called the complainant or the petitioner, and then we've got the respondent. Respondent is someone who has got the domain name registered. pertaining to which a complaint has been received. Now, reverse domain name hijacking, interesting. Deprive a registered domain name holder of a domain name. Supplemental rules are the rules of the provider. Provider, if you see, is right at the top of this page on the left hand side. This would be your dispute resolution service provider, which could be the agency where, say, WIPO Arbitration Mediation Center, other providers who provide this services, arbitration and all. I mean, this dispute resolution services. Now, moving on, what are the supplemental rules? So, say for example, say we've seen, who's a registrar we were discussing. So, if you look at the registrar, who could be there are some who voluntarily submitted and who are there. So these registrars, say in United States, you've got something called, there are several ones. Say host Australia, host Canada, host China, host Germany, host Japan. These are all of the United States. Then Internet Inc, which is Hong Kong. Then these registrar names are generally what we do not come across regularly. Say 123 Reg Limited, Domain Renewals.com, LLC, uh, GmbH Germany, 24/7 domains. So there's a whole list of them. uh, Now, for India, for example, there is a registrar known as Anytime Sites LLC. Then Appclonics Infotech Private Limited. Then say Big Domain Shop, say Big Rock Solutions, Blue Fractal. Click Registrar LLC, say Commerce Island LLC. There are these registrars which are located in India. Crisp names. There are a lot of them. So an entire list of registrars are there. So, say for example, a popular one is GoDaddy, where people register the websites. So, GoDaddy is one of them, LLC, which is there in the United States. So, all these are there. So, that's what register is. Uh, what is now, moving on to the right hand side of the screen? What does a written notice mean? Written notice means hard copy notification by the provider. Who is the provider? Provider is the place where dispute resolution, so who is essentially a dispute resolution service provider. Commencement of an administrative proceeding. So it should be a hard copy notification, which means it should be a printed notification, and the respondent should be informed. Who is the respondent? Who's registered the domain name against which a complaint is made. So essentially, it should be notified. Moving on, communications. How are they to be done? So it should, the operative words are actual notice. So it should be sending written notice to all postal mail and facsimile addresses. Moving on, all email addresses. So essentially this talks of proper notification. Now you can see the procedure. So due process should be undertaken. So when the complaint should be sent, as you can see, all documents should be attached with the complaint. Now F shows the proof of communications. On if it is sent by way of internet, then the date on which it was sent. However, it should be the date of transmission should be verifiable. The other portions are when it's been received. Now in under 2F, if there are three dates, date on which it is received by way of say email, second by way of fax, and third by way of post, the first date, that is the date on which it was sent by email, should be considered. Now again, communication and notice how it should be sent. Moving on to the complaint, this is important. Now anyone can, so the anyone can be the complainant for that matter. Now to whom can a complaint be made? Complaint can be made to any provider who's recognized. The list of is given on the ICANN on the WIPO website. Complaint would have to be submitted in electronic form. Then policy is something which we've just covered. The name, postal address, and email addresses of the complainant should be given, and then contacts should be given. This is the manner in which the complaint is to be made. Just like an arbitral panel or any other mode of alternative dispute resolution, one can have it's an odd number of members. It's either a single member or a three-member panel. In fact, even the respondent's address and coordinates have to be provided. Then domain name, which is the subject of the complaint, which is 6. So essentially it all revolves around this. Now, identification of the registrars. 8 is specify the trademark or service mark. I'm not reading out each and every word. uh, all of us would have different rates of speed of reading, so we can read it at our convenience. Now 9 is important, which shows the grounds. We have just seen who can make the complaint, what the complaint can comprise, on what basis can the complaint arise. When we were discussing policy, um, we were discussing under paragraph 4. So essentially those grounds. So under Roman 9, you've got 1, manner is identical or confusingly similar. The respondent would have to prove its rights, and you've seen 3. The policy, as we were seeing, paragraph 4b and 4c of the policy. Now, the remedy sought in accordance with the policy, that was Mr. Sushant Gupta had raised a pertinent question as to whether losses can be claimed. Interestingly, the policy does not say so. Policy just talks of the relief or remedy of cancellation of the name, and then or registration of the name in of the domain name in favor of the complainant. Now, Roman 11, other legal proceedings. As we've seen in the policy, the other legal proceedings can happen together along with the UDRP. Now, 12 is interesting. An undertaking has to be given that the complainant will submit to the challenge made to a decision in the administrative proceeding. Very interesting. We've seen what a mutual jurisdiction is. If you go back, you see mutual jurisdiction. That's towards the bottom of the page on the left hand side. Mutual jurisdiction means a court of jurisdiction at the location of the principal office of the registrar. So where the domain name, with whom the domain name is registered, or the domain name holder's address. So domain name holder's address is would be any jurisdiction. So either of those two jurisdictions would be a mutual jurisdiction. So this is where again the complainant will have to submit to the jurisdiction of the courts. Now, how the courts consider the panel an administrative procedure with the under the UDRP rules and UDRP policy, that will depend from jurisdiction to jurisdiction, because uniformly the courts may not treat them, and every domestic jurisdiction will have a different may have a different response in considering and treating, and also with respect to the sanctity of the directions issued by the service provider. Very interestingly, if you've seen the jurisdiction of the provider, which is say the seat of like a seat in arbitration proceeding, is not so important. It is either the place where the registrar is located or the party against whom the domain name is, or the respondent is office is located, the domain name holder's office is located, not the seat of arbitration. Rather, the seat of the dispute resolution is not very important as far as mutual jurisdiction is concerned. So the complainant will have to submit to the jurisdiction of the courts. Now this will make an expensive proposition, because say for example one is complaining for say somewhere someone in Jamaica has registered an Indian domain name just for the mischief of it, and then we complain, but we will not be able to do, it becomes a problem. And even if UDRP panel, the administrative procedure, rules in our favor, now if that party in Jamaica decides to challenge it there, it becomes a very costly affair and time consuming affair for that challenge to happen in some local court there. um, it would be a problem. So this is one drawback, or rather, it had given importance to the courts, so maybe it can be also be considered as a drawback. Now, the mandatory statement Roman 13 on the left hand side has to be made along with the signature. The complainant agrees. This is mandatory. This is something which we cannot change. Complainant agrees that its claims and remedies regarding the concerning the registration of the domain name, the dispute or the disputes resolution shall be solely against the domain holder, and waives all such claims and remedies against the dispute resolution provider. Very interesting. uh, Dispute resolution provider. And in case of deliberate wrongdoing, the registrar, registry administrator, and the Internet Corporation for Assigned Names and Numbers, as well as directors, officers, employees, ICANN. So one will not proceed against the dispute resolution provider and the others who've been mentioned here. Complainant certifies that the information contained in this complaint. This is something which we write in the courts also, something similar. Um, and the complaint is not being presented for any improper purpose. So documentary or other evidence is to be annexed, including the policy. Complaint may relate to domain name, provided they are registered by the same domain name holder. We had seen what consolidation is, where several disputes between the same parties can be resolved. Notification of complaint, verification request to lock the domain name. We've seen the definition of lock. Lock would mean that they will, during the dispute resolution process, that no changes can be made to the domain name. Now the procedure is given. Something the registrar will have to revert. Registrar is the body with which the domain name is registered. Now the procedure, as you can see on the screen, you can go through it. Now, if you see D, administratively deficient, it is if there are any defects in the format and matter. Concept of corrections being given, and moving on. Basically, the respondent should be reverting to the notice sent by the provider. Provider is the dispute resolution body. Now, in what format and manner it should be in, this is more to do with procedure. You can quickly go through it. Six is important, identifying any other legal proceedings in case the complainant's not mentioned that the respondent can mention. Moving on, again in a similar, followed by the signature in any, if you see 8 on the left hand side, conclude with the following statement followed by the signature in any electronic format of the respondent or its authorized representative. This signature in electronic format is something which we'll cover today under the Information Technology Act. Will uh, in your module Information Technology Act is mentioned, so I'll have to cover it and then we'll see as to what this means. Now D is important, interesting rather, in case the complainant says that, well, I will go by a single member panel, but the respondent says, against whom the complaint is made, says that I need a 3-member panel. They'll have to deposit one half of one and a half, one half rather, sorry, of the total fees of the panel. Else it will be a single member panel. Now, F is interesting. If a respondent does not submit a response in the absence of exceptional circumstances, panel shall decide the dispute based upon the complaint. Now, moving on to, now that the complaint and the response to the complaint is done, the procedure of intimating the parties is done. Now, the panel gets appointed and the panel makes a decision. Provider, again, the provider, for example, the WIPO Mediation and Arbitration Center, it would they will have to publish the list of panelists and the qualifications. Now, provider, in case none have elected a 3-member panel, then the provider would appoint one from its panelist, and in that case the fees will be entirely borne by the complainant. Now, 3-member panel, provider would appoint a 3-member panel. Now, in case the complainant says 3-member panel, it will have to be paid entirely by the complainant, else it will be paid by the respondent. Else, if the respondent demands, they'll have to pay half. Each will pay at the half fees. Uh, Now, if it's a 3-member panel, now one would be the complainant can give its list, then so essentially one from the name list provided by the complainant, one from the list provided by the respondent, and both can elect one. Now, panel being appointed, parties can be notified. Now, impartiality and independence, this is something which we've seen with a mediator, with a conciliator, also with an arbitrator. Uh, they will disclose, and this is very interesting, this phrase has been incorporated post the 2015 amendment in our local arbitration act also, Arbitration and Conciliation Act 1996, giving rise to, so we'll have to disclose to the provider under impartiality and independence any circumstances giving rise to justifiable doubts as to the panelist's impartiality or independence. Now, if circumstances arise that could give rise to justifiable doubts, the panelists would have to disclose that. Communication between the parties cannot be done unilaterally. It has to be done with keeping all stakeholders, including the provider. Moving on. Again, this is more to do with administrative. General powers of the panel, interesting. Panel would be conducting administrative proceeding in such manner in accordance with the policy and these rules. Parties are treated with equality, given fair opportunity. Uh, it has to be quick. In fact, even the evidence is left to the panel as to how they want to go about it. Consolidation is there. Language shall be the language of the registration agreement. Again, panel may decide. Further statements can again be done. There shall be no in-person hearings. Very interesting, there cannot be hearings by teleconference, video conference, web conference, unless decided by the panel. Default is there. Panel decision is important. Panel would be deciding on the basis of statements and documents submitted. Rules, any principles of law that it deems applicable. Panel, after taking a decision, will have to make a decision within 14 days. Quite a short time period given. Decision would have to be in writing. Now, E talks of the guidelines with respect to length. Now, if it is brought in bad faith, the panel can also say that, and that it's an abuse of the administrative proceeding. Now, communication has to be done within so many days. And when we are talking of the decision, it would also have the dissenting opinion along with it. Moving on. Now, in case the decision is made sooner, uh, now again it may be suspended on if negotiations are being conducted. Parties can reach a settlement. Then at any stage parties may settle. Now, moving on, this is very interesting. Effect of court proceedings. Now, as we've seen, this court proceedings have not been excluded. Court proceedings have not been prevented. Court proceedings have rather been allowed to continue. In fact, even before and after. In fact, parties have to give an undertaking as to mutual jurisdiction. Now, what is the effect of court proceedings as per these rules? Uh, Legal proceedings initiated prior or during administrative proceeding in respect of a domain name dispute. So whether it should be suspended or terminated or proceed to a decision, the panel would decide. And in case legal proceedings during the administrative proceeding is initiated, then it has to be notified. Fees again is as per the provider and how the fees is to be paid. Now they will start taking action only upon receipt of fee. Now exclusion of liability, amendments, and all of it. So I mean the rules can be changed from time to time. So now let us come back and think as what could be something which we can after going through discuss and take a call as to now quickly let's go over the questions. Domain name registrar has great responsibility. Domain name registrar cannot be is generally not made a party to the dispute. It is the party who's registered it is who's made a party to the dispute. Mr. Riazuddin Qazi. Good question. Uh, Mr. Vijay Natkar, yes, ICMI should be, putting it up the lectures. Good evening to you. Mr. Sushant Gupta, what is WIPO ICANN? WIPO is World Intellectual Property Organization. It is under the United Nations Economic Social Council. Now, and very interesting, Ashwini Kumar Singla. I think notwithstanding the fact that policy is silent about compensation for loss, reputation, pecuniary, one can always approach court of law. Perhaps that would be the correct answer, Ashwani Kumar Singla. You are right there, because in since the policy is silent about it, but the policy does not even also limit the remedies. Here, if the remedies have been kept very narrow and limited, and the scope has also been kept accordingly. So here you are right there. One can always approach any other court of law, and that route is never closed. Uh, Mr. Singla has got another question. Interesting. Is membership of I take that as to be the Chartered Institute of Arbitrators helps in getting business in India, or just wastage of considerable money? I'll pass that question. Um, Now, with respect to the decision of the panel, if you see there is no specific appellate authority mentioned, we've gone through the policy and the rules together. So, as far as the decision is concerned of the panel, you must have noticed that they talk of the local courts, and then they also talk of the mutual jurisdiction. That concept is there. So, essentially, they are looking at it being challenged in a court of mutual jurisdiction. Riazuddin Kazi has a question, interesting question again related to your earlier comment. Can a complaint be filed against the domain registrar for registering names similar or very close to existing name? Perhaps no, not under the WIPO rules. That's we've gone through the rules together. We did not find anything of that sort. But within the courts of the local jurisdiction, perhaps that may be open. We will be covering portions of further portions on INDRP. If today I get time, I'll do it today. Else, I'll do it on the next day. The Indian Domain Name Dispute Resolution Policy. I want you all to go through. So whenever we are going through any document, or instead of an analysis, it's best we get to see the raw text first. So that is with that objective, I had introduced both the policy and the rules. And in fact, even with the Arbitration Act, we'll be doing the same thing in the same manner that we did for conciliation. It is best that we look at the bare provision of the law and then get into an analysis. Now, let's put this question to the House. What do you think would be the advantages of and disadvantages of this administrative procedure, which is, as we've seen under the Uniform Domain Name Dispute Resolution Policy? What, according to you, are the advantages, and what, according to you, are the disadvantages of the Uniform Domain Name Dispute Resolution Policy? You all can write it there, and we've gone through the policy, we've gone through the rules, the merits and demerits, and then we'll be having a quick discussion on this before we move on to information technology. Um, so let's take a small break, and then I think within this time also I can get some more responses from you on the question as to what are the merits and demerits, according to you, of the Uniform Domain Name Disputes Resolution Policy that we've just gone over. Let's take a 10-minute break, and then we can come back with your answers on this.